Hello, everyone. Welcome to Carver Conversations. My name is Venkat Pingali. I'm the founder and CEO of Carver Agents. We work in regulatory risk intelligence. Today, we have a very exciting topic around data in a weaponized world. We're going to touch upon sovereign data, data center operations, hyperscalers, and what it takes to build credible control in a low trust world. These are very complex areas with technology elements as well as legal elements. To give a legal perspective, we are very fortunate to have Krishna with us today. Hemant is a partner at Shardul Amarchand Mangaldas in Bangalore. As many of you would know, this is a top TMT legal advisory service in the country and very well regarded across the world. At Shardul, Hemant is part of the technology and corporate M&A practice. He also advises technology-focused transactions and regulatory issues across digital infrastructure, fintech, privacy, emerging technology, and so on. One thing that we share in common is that he is also a legal tech entrepreneur. So ability to navigate uncertainty is something that is coming very naturally to him. We'll spend about 40 minutes discussing. These are loaded topics. If folks would like to continue the conversation, we will leave the contact information for Hemant and ourselves at the end of this session. There is only one disclaimer. The views and the opinions that are expressed in this program are those of the speakers and do not reflect the views or positions of his or our employers or any entities that we represent. With that, I'm very glad that we're able to talk about this. This is a topic that is very close to my heart. Carver was started with the idea that we are entering into a weaponized world. And what surprised us was the pace and the scale at which the issues are emerging. We are going to focus on one complex topic around sovereign data in the weaponized world. Thank you, Hemant, for joining us. Any initial thoughts before we jump in?
Thank you, Venkat. I'm looking forward to this conversation. Like you already flagged, I think it's going to be a fairly complex set of issues that we are going to talk through today. Hopefully, what ideas we exchange on this chat will stay relevant at least for a little while.
Oh, I almost certainly see that. If you look at the pace of events, like last 2 weeks, AWS data center has been attacked in Bahrain and UAE, industrial infrastructure in Kuwait and Bahrain, internet disruption, and a lot of responses from all of these providers in the form of traffic routing, shutdowns, restrictions, and so on. There is a lot of activity that is going on. At a top level, when you see all of these events moving, what is your take on the legal implications of this attack on digital infrastructure?
Yeah, so thanks for that question. I think this is not the first time that data centers have become targets in an international armed conflict, but this is possibly the first time that such attacks have targeted privately owned commercial data centers. And this has, of course, thrown up some very tricky issues of law. At a more sort of international law level, I think data centers assume tremendous significance when there is an international conflict, especially when parties to the conflict look to leverage AI. It could be to store and process intelligence, analyze satellite imagery, it could be to carry out any form of algorithmic analysis. From the perspective of international law, the strikes that you are referring to present a very tricky scenario where a data center may be dual use in the sense that it simultaneously hosts military and civilian data. Right? So for one, the law of armed conflict does not offer easy answers on the lawfulness of targeting such a dual use data center. The law is actually even more ambiguous when there's uncertainty about whether a data center was indeed in use for military purposes at all, as is the case in this instance, right? So on the other hand, from a commercial law standpoint, when we talk about the private parties that are involved, I think the question is whether the strikes amounted to acts of war that in turn trigger force majeure clauses that excuse the service provider from SLA obligations. The instinct of a service provider in such a scenario would naturally be to reach for the force majeure exception. But if a dispute were to reach the courts, there will be additional questions around, was the risk foreseeable? If yes, did the service provider take proportionate measures to manage that risk? And in such a context, even contractual language can go a long way in determining what is the extent to which providers may face liability for any service downtime.
There
So
are,
it's a complex set of issues, and
yeah.
there are no easy answers. And even from the perspective of the laws that govern conflict, this is a particularly nuanced issue which will require a whole lot of interpretation around what exactly happened in factual analysis as well.
Yeah, there is in the definitely in the legal and the tech community, AI governance community, there's a lot of now discussion on evidentiary burden, reasonable care. These are all the terminology that is getting introduced. But it sounds like this is just a point in time. This question of sovereign data and sovereign digital infrastructure has been building up for a while now. Is it just about these recent incidents, or is it a larger journey that we are taking towards the question of digital sovereignty?
Yeah, I think if we go back around 20 years or more, maybe the Snowden files were the first ones to put spotlight on the FISA Act amendments in the US and the scale at which governments may sometimes collect data, not just in relation to their own citizens, but also on citizens of other countries. Right. So then the GDPR and the cases under the GDPR underscored the tension between access requests from the US government and localization and sovereignty expectations of the European Union. So the enactment of the Cloud Act, which followed in the US, which gave authorities the power to request data from cloud and other service providers, regardless of where that data physically is stored, that caused a lot of countries to sort of reactively assess what would happen if sensitive data about their citizens became the subject matter of access requests by foreign government authorities. Right? So we should note here that for most part of the quote unquote cloud era, the template was for American service providers to be the suppliers of cloud services to most parts of the world, barring perhaps China in some cases, right? Now, this template has come under a fair amount of pressure, more recently when Russia attracted sanctions owing to the war in Ukraine. And now in the AI era, nations have started to realize that geopolitical shifts could very quickly decouple them from the entire global economy or the global cloud. So the questions they are asking are really around what happens to our defense systems, what happens to our healthcare system, what happens to our banking infrastructure, or any other critical digital national infrastructure if a foreign player chooses to weaponize control over their cloud services, the data of this country, or the AI workloads.
And one interesting dynamic that I see as a engineer in this whole space is that the complexity and the interconnections between the applications at all levels of the software stack are dramatically increasing. It's not just the cloud. There are like five more levels of application. Salesforce provides something, SharePoint provides something, and then there are these third-party services, application services that provide. So it is also a question when we drive down the sovereignty part. There is also the question of how can you even untangle all of this? If the GCCs are operating within your country and they are part of this larger web of relationships at a technology level, how do you enforce sovereignty? And this is today's situation. And with AI, the whole thing is getting even more blurry, the lines.
I think we should take a step back and ask the more fundamental questions of, if you look at it from, let's say, the perspective of a government, what exactly does sovereign mean? What did it mean in the cloud era? What does it mean in the AI era? Right. So, I mean, loosely speaking, I would say that from the perspective of a government, sovereign can be equated with control, right? So previously, data centers really used to be so-called colo data centers or edge data centers, and that supported applications and transactions and were geographically close to the locus of the transactions that they supported, financial, e-commerce, streaming, whatever else, right? And in that context, latency was a huge consideration, and data centers were always in located in physical proximity with the locus of the transactions. But fast forward to now, we are now talking about the data centers that foundation models rely on. They're sometimes known as AI factories. Now, these are not really very latency sensitive, and they're not necessarily established in close geographical proximity to where it's used. But these data centers are really giant power guzzling behemoths. They could be established in one country using the services of maybe hyperscalers from a different country, connected through cables on the ocean floor. It's a completely different ballgame, right? So I think in this context, this whole idea and paradigm of data residency alone being equivalent to data sovereignty starts to become less and less relevant, right? Because for governments and GCCs now investing in digital infrastructure, and like you pointed out, the interconnectedness of what it takes for any AI specific data centers to be functioning. I think in that context, it's not just about ownership of the data center or residency of the data, but it's, sovereignty could in that context involve assessing your entire stack from physical infrastructure layer to the software and the model layer to the operational layer and the entire supply chain in between, and looking at, okay, what can be controlled and what is worth controlling, right? And the thinking around that really starts with also which vendors in the supply chain present risk and what is the extent to which that risk can be mitigated.
Yeah, there is now we are in the territory of forecasting prediction in terms of where the both the technology evolution will take, where the relationships between countries, the trust levels that exist, what are the choke points that could develop over a period of time, and so on. Here, there was I just want to point out one thing. A friend of Carver, who runs a GRC system out of Dubai, he had scored all of the current AI offerings in UAE and along three dimensions. One is, of course, residency. The second one is, do you really have the freedom to opt out of the training process itself? And the third one was inference. Do you really control the inference in region, out of region, and so on? And the interesting observation is that pretty much they have no option on most of these dimensions, and that has set off a bunch of conversations in the community itself. But coming back to this AI blurring a bunch of these borders, right? Now they're operating in so many different jurisdictions. I mean, not just geographical jurisdiction, but also domain. For example, if there is a biometrics related processing that is happening on ChatGPT, in the data is from one country, the data center is in a second country, the applications and the control are in the third country. Now we are looking at a very messy situation where, like you said, if we start asking what should we control and how much should we control, it becomes a national security question, it becomes an economic security question, and countries may or may not have the means, motive, and opportunity to like evaluate all of them. We are looking at a very complex situation now. It almost feels like the sovereignty is an illusion. You either are part of this larger web of relationships and somehow cope with it, or the Westphalian notion of sovereignty and so on, that has to be deprecated, and we have to define a new set of rules of engagement across all of those countries. How do you see this evolving over the next so much time?
Yeah, I think that's a great set of points that you made, but I wouldn't go so far as to characterize it as an illusion, simply because between saying that, look, I want to control everything and using what's a picks and shovels kind of an approach,
Mm.
to to saying that, okay, sovereignty is an illusion and therefore I won't care, you know, no matter who controls what component of my AI stack, so to speak. I think there is a lot of meaningful ground in between that
Mhm.
requires careful navigation, right? So, again, from the standpoint of a government, it is always useful to ask where the data lives, but also ask where are the AI workloads? How much control do I have over the supply chain? Right? Who controls the underlying value system of the AI models? Because, especially in the context where the foundation models are designed somewhere else, trained somewhere else, the hyperscalers are located somewhere else, and there is no real geography specific data set alone that makes for training data, for example. It's also important to understand what is the value system that the users from a particular country are going to be exposed to when they interact with a model, and is that a good thing from that country's perspective, or are they likely to perhaps be influenced by the views of an adversarial state, right? And can a foreign government or a foreign court or a foreign vendor access, suspend, or process data without my knowledge or consent? Right? These are all questions that start to become relevant when you wear the hat of a government that's looking to set up a sovereign AI data center, and looking at what is the feasibility of setting something like that up, right? Because ultimately, like you pointed out, inference is almost always going to happen somewhere else, and that is already a source of exposure, right? So what I would say is, it's neither that absolute sovereignty is possible, nor that the very idea of sovereignty in an AI context is an illusion, but it's that there are a set of sovereignty objectives that are achievable through technical and operational measures, right? And another set around which you will need a whole lot of legal and contractual and compliance overlay and engineering to mitigate risks to sovereignty.
It's almost like you have to create options for yourself in this world. For example, if you look at, you mentioned about the value systems. Dario has explicit political views, right?
Yes.
Now, any foreign government that is listening to him would be very concerned about technology that comes with its own values that today is aligned but may not be tomorrow, right?
Absolutely.
So then the question of how do you create realistic options for yourself to protect your sovereignty under various possible scenarios. You talked about, of course, data residency and some of these requirements. In your view, is there further capacity building that needs to happen to even have options at the table? So, for example, a sovereign foundation model it's a national champion. It's one of the tools in the toolkit. In your experience, can you think of a few others? What do you expect governments to do?
Yeah, I mean, I don't want to comment on specific configurations of, data centers and models, but I think the intuitive understanding that most of us have when we talk about data sovereignty continues to somehow be centered around storage and access, right? Can someone read my data, get hold of my data? But I think with AI, the point I'm trying to make is that there are other questions that
Yeah.
may be even more consequential. Take, for example, learning in an AI context, right? Has my data permanently altered a model that someone else controls? In case of the example that you cited, in fact, Venkat, I think these are all questions that would have been asked, right? If my data is processed in a foreign data center, what are the other sources of data that are commingled in the model aside from my data, right? And who has influenced the values, the biases, the boundaries of that model? Now, it's important to remember that when your data trains a foreign model, you cannot really hit an undo or a recall button on that interaction, right?
Yep.
The model has more or less permanently ingested that data, encoded in weights that belong to someone else in a jurisdiction where you probably do not have control, and you don't really have any meaningful erasure right of any kind. But interestingly, as awareness about these risks is growing, there are also tools that are emerging that can help mitigate these risks as well. So, which I think is the source of comfort for many players looking to set up sovereign data centers.
We definitely are seeing a lot of activity on the commoditization of this entire tool chain. For
Right.
example, now we are talking about 10,000 possible models, not just a handful of extremely large models. We are talking about culturally aware models that reflect the local considerations and so on. All of those are at the table. Now, one question here is that if I build an application, maybe I'm an American company, maybe I'm an Indian company, maybe I'm a European company in a particular data center, I'm running an application. Where does the legal risk for me as a company come from?
Right. So I think there are three sort of known sources of legal risk from recent experience. First is legislation like the Cloud Act, for example, in the US, under which US authorities can compel disclosure of data held by US headquartered companies anywhere in the world without notifying the data subjects, without domestic courts having any prior opportunity to intervene, right? The second is the extraterritorial reach of sanctions regimes. For example, I mean, this threat doesn't really come just from the US, it could come from the EU, like a recent case illustrates. And when applied to an entity anywhere in the world, a foreign incorporated vendor might have to suspend services despite the customer being fully compliant in a third country, right? Learning from a more recent situation, I think, there could be a scenario where a government designates a technology vendor as a supply chain risk and potentially persuades entities in other countries to cease commercial engagement with that vendor. Now, this is a third source of risk that we now know can exist. But I think as this technology evolves and there are newer instances of sovereign data centers being set up and new forms of engagement with hyperscalers, there will be newer risks that will come to the surface as well. And it's important to stay abreast of the direction in which this evolves.
Absolutely. At Carver, we have been tracking this regulatory policy shifts across the world. I can tell you that we've been very busy with the amount of everything from sanctions to guidances, aggressive enforcement, these ramping up. And also equally interesting, we see a lot of coordination across geographies where
Sure.
the governments are aligned to a particular political objective. Now, it sounds like it is almost inevitable that there will be a conflict where the EU AI Act will conflict with the US Cloud Act and the DPDP Act and so on. How do you see this legal disputes being resolved? Will it happen at a political level, at a instrument level, or what do you see as the mechanisms to sort out these disputes?
Um, I don't want to comment on how these disputes are likely to play out because honestly, that's crystal ball gazing that I don't want to do, right? But I think it's more important and more sort of productive to ask the question as to what can private firms involved in, setting up services and service lines which may come in the process of such a conflict, what can they do, right? To be honest, there is really no hierarchical framework of any kind to resolve a conflict among these laws, right? It's a classic case of three regimes built on mutually incompatible assumptions, all simultaneously asserting jurisdiction over the same data set and all three imposing actual legal consequences for non-compliance, right? So, for one way for a firm that is present in multiple jurisdictions to approach such a structural conflict would be to ask whether there is a more architectural solution to the problem. For example, let's say at a basic level, customer controlled encryption may render a provider technically incapable of complying with a decryption demand, right? Likewise, consider the sovereign sensitivity carefully. Ask which data must stay on sovereign infrastructure at all costs, and which can be perhaps with the hyperscaler with contractual protections, and which can perhaps move freely. I'm sure, I mean, even in a sovereign data construct, it's not that every every data has, or every piece of data has the same level of sensitivity attached to it, right? Of course, if you find yourself in such, in the nucleus of such a conflict, and you've not done an assessment like this beforehand, then you end up being guided by pragmatism, and you prioritize the sovereign whose consequences are perhaps most immediate and severe for your specific business. But that is only if you've not had the opportunity to consider this beforehand, I'd say.
No, I think you pointed out exactly the reason why we are hosting this conversation, right? As technology architects, AI architects, knowing that you are walking into regulatory or legal gray areas and you creating the levers at a data level, at an application level, or an algorithm level will save you a lot of potential headache down the line. I mean, even, for example, you talked about encryption. What we know is that regime is only for another like 5 years.
Yeah.
And so we are going to revisit even some of those tools that may be there with us. But it is very important that the engineers in the audience really take this advice seriously, that their choices can dramatically influence the legal situation that the company will find itself in. And therefore, if they are informed, they can make a different set of technology choices and become more competitive in the marketplace. It sounds like, the new generation of companies, especially even companies like mine, which are almost global from get-go, now has to be very strongly informed by a set of different experiences, not only legal, but also geopolitical, and we are talking about cultural and so on. And the role of the councils at each of the companies is becoming more and more important. What, in your view, how did your experience help you, give the best possible advice to your clients? And what do you advise the next generation of lawyers to equip themselves in order to, advise them or understand and grapple with all of the complex situations that technology is going to present themselves?
Yeah, sure. I mean, in a lighter vein, I sometimes think that all this discussion about sovereignty will be rendered redundant the moment somebody sets up the first data center in outer space. But that aside, I think in general, just by virtue of how dynamic this space is, I would say you need to be slightly obsessive, and you need to have a cross domain curiosity to learn across technology, geopolitics, regulation without really treating them as silos. And quite frankly, there is no playbook, right? And the landscape is just way too dynamic. And I think what matters is developing a reflex where you read something in the news and you instinctively map it onto your client's risk surface. Does this shift exposure? Does this create a new compliance angle? Or does this open up a strategic option? Right? So if you're consistently making those connections as you go, you're perhaps operating with the right instincts to advise in this space and the right mindset, right? As for advice to the next generation of lawyers, I'm not sure I'm qualified to offer advice to an entire generation of lawyers. But certainly, what's helped me is a skill that I like to think of as helicoptering, right? It's the ability to look at the same problem from different heights and angles, to zoom in on the details when it matters, to zoom out to see the bigger picture, and then just collapse it all into usable advice for your clients, right? So, in a world where the legal profession is perhaps among those being most radically transformed by AI, clients don't really need lawyers who operate within these narrow, specialized silos as much as they need lawyers who can connect really disparate dots. And they can anticipate where things are headed and translate that instinct and judgment into advice that clients can act on.
No,
So,
absolutely. Yeah, I mean, As even as an engineer, I've been following the legal profession for a while because I was interested in antitrust and competition and copyright and some of these technologically heavier topics. And I think that this breadth of experience, worldly experience that you have, and the many perspectives that you can bring to the table is very important. And that was one of the motivations for having this conversation. This is primarily intended to bring two relatively siloed domains of engineering and legal together, because now we have to solve the problems together, right?
Sure.
In the coming years. Any closing this session? Do you have any thoughts on a legal rule or a law that doesn't exist but should exist or could exist?
Oh, it's a tough one. There could be just so
Yes.
many, right? I think for starters, maybe a rule of obsolescence that makes it illegal to quote anything that anyone has said about AI 3 months after it's been said.
Okay. Now it is 3 months. It'll be 3 weeks, a couple of years from now.
Yeah, yeah, absolutely.
Yeah, I mean the idea that the timelines of everything is shrinking. The company products, ideas. It presents tremendous opportunities and also challenges. With that, thank you very much, Hemant. It's been absolute pleasure. I would love to continue this conversation. The For the audience, especially engineers for whom this podcast is intended, please actively engage the legal community, because together we are the shapers of the reality, and this poses tremendous challenges to the rest of the world who are at the receiving end of what we create. And with great power comes great responsibility, as the philosopher Spider-Man said one day. With that, thank you very much, Hemant. Would love to be in touch. Thank you very much.
Thank you. Thank you. My pleasure.